or Park City Surgery Center, LLC, DBA Park City Surgery Center, United Surgical Partners International, Inc., Baylor Scott and White Health, THV Park Cities, LLC, Texas Health Ventures Group, LLC, USP North Texas, Inc., PC, Surgical Investors, LP, PC Surgical Investors, GP, LLC, and Doctors Tarek Sorial and Philip Smith, MD.
That everyone?
Your Honor, David Chris, I'm here for Dr. Joseph Lavoie and Dallas Anesthesia Associates, PA.
Okay, let's get started.
Your Honor, we're here today. All the defendants except for Dr. Lavoie and his group, Dallas Anesthesiology Associates, filed this opposed motion for leave to have our motion for summary judgment as to causation and motion to exclude 3 of plaintiff's expert witnesses set for hearing before the specially set trial date of February 28th. We filed our motion for leave that's opposed. Plaintiff responded, and I'm happy to go through the individual points and address the issues that plaintiff raised, but I wanted to just start out and say that the overarching point to be made with our motion for leave and the response to plaintiff and the reply to plaintiff's response is judicial economy. Without getting into the specifics, the crux of our motion for summary judgment.
Let me ask you first. I know I have a general policy that says that it should be 30 days before trial. Was that in the scheduling order?
No, Your Honor.
Yes. Yes.
It wasn't. I don't know. I don't remember.
I can tell Your Honor, I'm not trying to mislead the court at all. I know that we looked at your local rules and we didn't see it written out in your local rules that are online. And so that was part of the reason why we filed this motion for leave, and understanding that the court has your rules. But we feel an exception should be made in this circumstance.
It's not a rule. It's just a preference, to be honest. I do encourage people to include that in their scheduling order, just because I've learned over the years that makes things more efficient. But so that's why I was asking. So if the issue is, can you set it within 30 days and it's not in the scheduling order, I would say that's fine. You know, I don't like it that way, but it's just a preference. But if it's in the scheduling order, then you would need to get leave. And that's what I don't know. I don't have a local rule on it or a policy or anything. Does anyone want to, or I can look up the scheduling order.
Well, the scheduling order that was in effect before this last one had the date to file motions for summary judgment and dollar deadlines as July 15th of 2022. And there was a scheduling order after that, but it does not include any change in that particular deadline.
But Your Honor, to answer your question, there's no language specifically in any of our scheduling orders that say that these motions need to be heard before 30 days before trial specifically.
Well, he says it was July, right? It had to be heard by last July. No,
right. Well, the reply to that response, Your Honor, is that none of the experts that we've moved to exclude had been deposed by then. So plaintiff's argument is illogical and brings us back to the same conclusion because, okay, we could file motions for summary judgment based on the plaintiff's expert reports, but we would have come to the court and the court would have been like, well, you need to depose these experts and then we'll talk about it. The last of these experts was not deposed until December 17th of this year of 2022. So we would have been in the same situation that we are here today. And we would be at this hearing still because depositions weren't concluded by anywhere near July of 2022.
okay. Response?
Yeah, thank you, Your Honor. First, we designated our experts in March of 2022. They had plenty of time to designate to depose our experts even before they designated their own experts. Mr. Anderson filed a letter or sent a letter to us saying that they will try to do our experts after they've designated their own. There's no reason for that delay. This case is set for trial, especially set number one for trial on February the 28th. If they gave us required 21 days notice right now, that would put the case set for motion for summary judgment on the day before the trial. It would mean that we would have to respond with affidavits and deposition testimony and all that we need to do sometime in the next 21 days while we're getting ready for the trial with, probably 10 lay witnesses and maybe 10 to 15 expert witnesses in this case. I mean, it would create a hardship for everyone involved in this case. If they would have wanted to file motions for summary judgment, motions to strike, they should have tried to include that in the scheduling order that they drafted, the amended scheduling orders, but they did not do that.
Who joined in this with Ms. Hirschman?
Counsel for the surgery center, Your Honor.
Yes, we did, Your Honor.
Jones, what is your argument here?
I join in the arguments of Ms. Hirschman. I think that we were really not in a position to entertain and make the arguments with reference to the motion to strike these three experts or exclude these three experts, as well as the motion for summary judgment, until we had all three of the plaintiffs' experts, the last one being Dr. K. And prior to that time, the evidentiary ducts would not have been lined up for a motion for summary judgment to be filed. So we enthusiastically joined in the arguments of counsel for Dr. Manning.
So have these summary judgments and motions to exclude been filed already? They just haven't been set? Is that the idea?
Yes, Your Honor. We filed them on January 20th. And then when we reached out to the court the following week, we were informed that we needed to file a motion for leave. So we reached out to plaintiff's counsel. Plaintiff's counsel opposed. Therefore, we filed our opposed motion for leave and set it for hearing. Today was the soonest hearing that we could get, which is only a week after we filed the motion for leave. Your Honor, if I could just interject, the issue here is that plaintiff's three causation expert witnesses opine on a joint causation theory. So with any one of them, had they testified differently, we wouldn't be here today because one of those experts would have then checked the box for plaintiff on her causation theory. None of them have a separate causation theory from the other one. And so we needed all three so that we could say collectively, all three of plaintiff's experts failed to prove causation. Causation is obviously a required element of the plaintiff's claim, and it seems as if that is an issue that would be better suited to be ferreted out pre-trial rather than getting into a 2 or 3 week trial and then trying to ferret out that issue.
So this is kind of my thoughts. This isn't a ruling, but this is kind of where I'm leaning, is that we set the motions to exclude. I'm sure all of you guys, I've been around a while. You guys have been around a while. I mean, I don't historically have not granted a whole lot of Dalbert challenges in these types of cases. I mean, I have, but not very often. And so if there really is a good Dalbert challenge, what I will typically do, especially if it's this close to trial, is, my thought is maybe we set it the Friday before trial. If I do grant it, then I would probably give them a continuance to try to find a new expert. And then at that point, you can move for summary judgment. That's, to me, kind of the fairest way to do this. I share Mr. Hart's concern about trying to do a summary judgment the day before trial. I know how that is getting ready for these kind of cases. And so, Mr. Hart, I know that's probably not exactly what you want to hear, but how do you feel about that?
This is a big trial with lots of witnesses, and I'm going to be spending pretty much 100% of my time getting ready for this case just for the trial of the case. And now we have to respond to what we believe is nearly frivolous Dalbert motion when one of our experts is probably the leading expert on the causation in this on this issue in the world. And it was testified that 90% chance this is, our theory is what happened in this case. Making us have to spend the time and effort and money to respond to this case at this late hour when they could have filed this, and they could have taken the deposition of the last witness, Dr. K, back in August when we took the other two doctors' depositions, but they canceled it 2 times. And then when they did get it done and then they waited like 6 weeks to even respond to my offers to give them new dates. And then when they did, they didn't ask the court reporter for a rush. So they didn't get the transcript back till January. Then they wait another few weeks to file their motion. This is a delay and an attempt to take advantage of the more lawyers they have on their side to the 1 or 2 lawyers we have on this side. To keep us busy doing something other than preparing for trial. It places an incredible hardship on us and plaintiffs.
I mean, the alternative, and again, I have no idea. I don't know I haven't read the motion to exclude. I'm not commenting at all about any merits. Is if we go to trial on this and it turns out your expert has to be struck, then you lose the trial, right? I mean, at least with this, if I do strike or is it not, is these experts not critical on the issue of causation?
Well, I think I'm sorry, I jumped in on you at the end. The experts are critical, but they're not case critical because the treating doctors in this case, in the medical records before there was ever a lawyer involved, said that our causation theory is what happened. Exactly what happened. And isn't that what Daubert wants to get rid of, is cases that are different than what the medical records and expert opinions brought in just for trial and instead of for medical treatment or scientific purposes. I think we win just based on the medical records.
Well, Your Honor, I'm happy to have a discussion about Mr. Hart and his opinions, but today is not the day to be discussing the merits of his causation claims. We're here today to discuss whether or not we should be granted leave to set these motions for hearing. Mr. Hart is trying to argue the merits of his response to my motion to exclude at an inappropriate time.
Let me ask you, Ms. Hirschman and Mr. Jones, I mean, does this compromise, if you hate this compromise too, then I just have to make a decision one way or the other. If you're okay with this compromise, I'm more likely to at least do the compromise. What do you think?
Your Honor, I'm happy with the compromise to at least have one of our motions heard before trial.
Mr. Jones?
Me too. I agree with Ms. Hirschman.
All right. Sorry, Mr. Hart. I'm trying to be fair here. I understand your position completely. I am concerned that, and I don't know what the causation issue is, but if I don't want to given how backlogged we still are, the courts here, we want to be able to try cases that are actually going to be finished. And so I'd hate to start this trial and then it turns out you should have been dismissed because there was a faulty expert. I'm not saying that's the case, but I'd like to get this resolved anyway. Why don't we just do this? Are we going to have other pretrial issues besides just the Daubert that we need to, are we going to have line and page designations? Are we going to have lots of motion limiting issues? Or should we do a pretrial conference and just include this in it?
Yes, Your Honor. We were going to reach out to the court about a pretrial hearing anyways, because of the vast issues in this case. It's going to be a lengthy pretrial conference.
And the trial's on the 28th, correct?
Yes, Your Honor.
Okay. I can do a pretrial, I hope. Let's have a trial on the 24th. So Rhonda, are you there? Can you contact Rhonda? You want to shoot it for 10?
For 10?
Are y'all local?
Yes.
Yeah, we're local.
And there's people are flying.
Oh, yes, sir. I believe, or Your Honor, I believe all counsel is local.
So Rhonda, go ahead and set this for pretrial at, I don't know what she's doing. Let's see. Is she coming in or what's she doing?
Yeah, she can. There she is.
All right, on the, give me the cause number on this, Ms. Hirschman.
Sorry.
I've got it.
Okay.
It's DC 20-14588.
So we're on this case on Friday, the 24th at 10 o'clock. We're doing a pretrial hearing and motion to exclude experts are going to be set at 10 o'clock that morning. And try not to send anything else after 10 that day, unless it's already said.
Okay,
So just tell Kelly that.
we'll do.
All right, guys, anything else?
That's it, Judge. Thank you.
Just hope the court's opinion about the trade is good.
The hot sports opinion.
Yes, sir.
I mean, he's got a ton of talent if he'll just keep his head in the game.
Yep.
Right?
It's all about the head.
Yeah, so let's hope it I hope it works out. Luca, I'd love to see Luca win a championship. So all right, guys, you guys,
Absolutely.
Thank you, Your Honor.
we'll see you at the next one, okay?
Thank you.
Thank
All
you.
right. Thank you, Judge.
All righty. Do we have both sides here on the Ford v. Ansari case?
Yes, Your Honor, I think so.
Yes, Your Honor.
All right, Tony, let's go on the record on DC 222786. Counsel, make your appearances.
Juno Lazatin here, Your Honor, for plaintiff, Mr. James Ford.
David Oden's on behalf of the defendants.
All right, let's go ahead and proceed.
All right. Your Honor, this is the defendant's motion to reconsider the court's entry of a partial summary judgment with a number of non-suits that were then filed. Ultimately, it's going to be the final judgment from the court. The response says that we're trying to re-argue the motion for summary judgment or to submit a new motion for summary judgment. And I want to be clear what this motion is not. It is not an attempt to rehear the motion for summary judgment. We're not attempting to offer any evidence. The motion is directed to the relief that was granted in the partial summary judgment order that as a matter of law was not available then and is still not available to Mr. Ford. And we're asking the court to enter a judgment in this case for trespass with $350 in actual damages plus court costs, but not to award any attorney's fees. As the court may recall, this is a neighbor dispute over a trespass. And on December the 5th, the court entered a partial summary judgment. The actual damages, as I said, were $350, but then under the Declaratory Judgment Act, the court entered attorney's fees of almost $21,000. We're asking the court to reconsider because those attorney's fees are not available in this type of case. Now, Mr. Ford's response is that this is a boundary line dispute. However, nothing that he was asking the court to do in the partial motion for summary judgment was asking to interpret the deed. Indeed, what they were asking was that the court approve the survey. And Your Honor, if I might be permitted to share my screen.
Oh, I'm
So-
sorry. Real quick, go ahead.
Okay. If we take a look at, is that available? Can the court see that?
No.
No. There we go.
Okay.
This was Exhibit C1 to the motion for summary judgment, which was the survey that was submitted that Mr. Ford was asking the court to approve. If you look closely at the survey down at the bottom, it specifically says this lot per plat does not mathematically close. Boundary is per evidence found on the site. That necessarily means that what the survey did was to redraw the lot without any reference to the deed itself, which impacts title. And once that happens, let me get out of the stop sharing. Once that happens, the court is now being asked to determine title to the property, not to interpret the deed, and it is determining the rights of possession of the parties. The Texas Supreme Court in the Coinmark Corporation case made it very clear that when the dispute involves the determination of the party's possessory rights to the property, 22.001 of the Texas Property Code is the exclusive method for determining title. That's trespass to try title. And attorneys fees are not available. It rejected that a party can use 37004C of the Declaratory Judgment Act in order to get attorney's fees. Most recently, in Armstrong DLO Properties out of the Dallas Court of Appeals, the court followed that decision, specifically holding as much. And again, let me see if I can bring this up for the court. Hang on, Judge, I'm having difficulty getting to here we go. This is the Dallas Court of Appeals opinion that talked about the plaintiff's contention that attorney's fees were recoverable because the declaratory judgment action was appropriate under 37004. The Dallas Court of Appeals noted the Coinmark case, specifically said that trespass to try title cases are governed by that statute and attorney's fees are not available. If you'll look, the court also in the Powell case said that any suit that involves a dispute over title to land is in effect an action to trespass to try title, whatever its form, and attorney's fees are not available. Ultimately, that's what we have in this case, Your Honor, because you were not asked to interpret the deed, you were asked to interpret the survey. And the survey, by its own terms, said it wasn't a complete mathematical close, which means surveyor had to make a decision as to what title actually existed. And as a result of that, attorney's fees are not available. We're simply asking the court to enter a judgment for the trespass for $350 in actual court and then the actual court costs, noting that trespass is a tort and attorney's fees are not available. You simply can't get there by using the Declaratory Judgment Act.
Response?
Yes, Your Honor. Oops. Yes, Your Honor. Pulling my notes up here. Your Honor, opposing counsel's in a difficult position to try and resuscitate the plaintiff's motion for summary judgment and try to re-argue the case. The defendant's response was an attempt to present new legal arguments, specifically regarding the survey and the interpretation thereof. Unfortunately, Your Honor, there's no legal precedent or statute opposing counsel can produce that supports the defendant's motion and is analogous to the situation at hand, which is the key difference here. The purpose of a motion for reconsideration, Your Honor, is to permit a party to correct manifest errors of law or fact with newly discovered evidence, which is presented to support such a correction. But the defendants here are trying instead to use the motion for reconsideration to effectively render a statutory deadline moot by arguing that any party responding to summary judgment can ignore response deadlines so long as they believe a valid legal argument exists. Your Honor, the deadline to file a response was November 21st. This was agreed to by the defendant's prior counsel and myself via emails attached to our response as Exhibit A. The court generally has no obligation to consider any additional motions on the issues adjudicated by the summary judgment. And here, the defendants are attempting to provide case law and arguments to respond to the declaratory judgment granted by the court in the previous summary judgment hearing. Your Honor, the court in Jenkins v. Stewart title provides that a motion for leave to file a late summary judgment response, which was what this motion for reconsideration appears to be, should be granted if the defendants are able to show that the failure to respond was caused by accident or mistake or intention and was not intentional or the result of conscious indifference. Defendants that provided none of that in their response in their motion. Furthermore, Your Honor, a motion for reconsideration is a request for post-judgment relief, and Texas Court of Appeals held that a motion to reconsider cannot be used as a method to defend or reply to the plaintiff's pleading, as this motion in it is not in itself a pleading. Defendants spent 4 of 7 pages asserting legal defenses to the plaintiff's claim for declaratory relief, But the bottom line is that the unexcused failure to respond by November 21st is not valid grounds for reconsideration. And in an attempt to mischaracterize the defendant's failure to provide a written response to summary judgment as being the same as a default judgment after failing to respond to the original petition, defendants are citing first to First Dallas Petroleum, DSC Finance Corp, and Doubletree Hotels Corp, and defendants are relying on case law that addresses default judgments after failing to respond to a petition, which isn't the case here. None of the defendant's case law speaks to a party's failure to respond to a summary judgment on time. However, Your Honor, given opposing counsel's arguments, even if the standard of the defendants are requesting the court to apply were applicable, they haven't alleged and cannot show that the facts in the plaintiff's partial summary judgment motion don't support the plaintiff's claims. Defendants didn't make an allegation of insufficiency of facts to support the claims asserted, and specifically the facts concerning the plaintiff's claim for a declaratory judgment. And instead, the defendants are now trying to assert an untenable legal argument as to whether the DEC action claim is proper and whether the attorney's fees granted were proper. And under the Civil Practices and Remedies Code, the plaintiff may obtain a determination by the court when the sole.
Mr. Lawson? Can you
Yes,
hear-
Your Honor.
So this is kind of my question, because I had this come up recently in a case. And so the new Court of Appeals, I think, has done a great job of, I guess they're not that new anymore, but of providing reasonable deference to the trial court. But I was reversed in one of my relatively rare on a situation where, and I think the Court of Appeals was probably right, that there was no response followed to a summary judgment. But if you looked at just the evidence that was presented in that case, just by the movement in that case, summary judgment should not have been granted. And so what I will consider here is, and I want to hear argument from you and Mr. Odenz about this, is based just on the summary judgment that you filed, was there grounds to award attorney's fees? Or based on just what you filed before, not considering any of his evidence or anything else, should summary judgment have been denied?
No, Your Honor, summary judgment should have been granted as it was, if I may. Am I?
Just 1 second. Ma'am, what are you here for?
I'm really trying to get a hold of the court reporter next door. The doors are locked, and I was gonna see if.
I'll take care of it. Just go ahead and have a seat up there and I'll get it, okay?
Thank you.
Good to see you. Go ahead.
Yes, Your Honor. Summary judgment should have been granted as it was, Your Honor, because the big difference here, Your Honor, it's not that we're using the declaratory action to sneak in attorney's fees, as opposing counsel is alleging. Opposing counsel even said in their argument that the declaratory action was snuck in via element 1 of the trespass claim. We're not necessarily disputing ownership as element 1 requires under the trespass claim. That wasn't in dispute, and it wasn't brought up by the defendants in a response. Ultimately, Your Honor, the way this lawsuit started is there are 2 neighbors who are unclear as to where the property boundary line is. And that's the reason why we were requesting the court to declare that the survey that we provided is an accurate depiction of the line. And that's the reason why we presented the expert declaration as well as the survey in our motion for summary judgment. Now,
so that brings us back to the issue, which is, if that is simply a dispute over title, the law isn't it, that I can't do this as a declaratory judgment, correct? Are you there?
yes, Your Honor. I'm not quite following. It's not the same kind of situation as what opposing counsel is presenting here. I'm sorry, Your Honor. Could you explain a little bit further? I'm not quite following.
Okay, sorry if maybe I'm not being very clear, and I apologize about that. So Mr. Odenz's argument is that this is simply a dispute over title. He agrees that that you guys should prevail on the trespass to try title, that you should get the title that you've requested, but that you should not be able to be awarded attorney's fees because under the Dallas Courts of Appeals and Supreme Court decisions that that you cannot use the declaratory judgment to decide issues of title. If he's correct, even just based on what you submitted, the law would be you shouldn't be able to get attorney's fees, as I understand it. And so that's what I'm trying to. The only thing we're going to be looking at is what you submitted. Mr. Denz, I'm going to have you respond to this. What you submitted in the initial summary judgment. I'm not going to consider anything else, but based on what you submitted, could you have gotten attorney's fees?
Hold on.
Are you guys hear me? He doesn't. Maybe I'm not.
No, I can hear you, Judge.
Yeah, I can hear you too, Your Honor. I'm pulling it. I'm pulling up my notes really quick.
I'll let Mr. Odens respond to that.
Sure. First of all, Your Honor, you're absolutely correct. The law is that if it involves an issue of title, then you can't use the Declaratory Judgment Act to recover attorney's fees. I think that's clear. And then the question is, what in fact were they really trying to do? The argument was, well, we're simply having you interpret the deed, and that's permissible under the Declaratory Judgment Statute under 37004. But again, if we go back, and again, Judge, I'm only referring to material that was in the summary judgment motion, and this is C1 at page 22 of the motion for partial summary judgment, where we set out the plat. You have the surveyor saying that this lot per plat does not mathematically close. If that's true, he can't draw the lines to any specific point. So what does he then say? Well, the boundary is per evidence found on site. That necessarily now means we're no longer interpreting the deed. We're using the survey to set where title belongs to one side or the other side, which then leads to the argument about whether there was a trespass or not. An argument, you're correct, Judge, is straightforward. Once it involves title in any form, it's only recoverable by a trespass to try title, for which attorney's fees are not available. We're not, and I want to be clear, we're not relying on any evidence. We haven't submitted any. We're simply relying upon what's in the summary judgment record that the court considered in December.
Okay, response? Response?
Yes, Your Honor. Your Honor, oops, sorry, chair broke. Your Honor, plaintiff's contention is that the statute is clear, that under 37004C, in this type of event, we are entitled to attorney's fees under the Declaratory Judgment Act. Your Honor, the difference in this case is it's not a title dispute per se, Your Honor. This is where the definition of the line is separate from whether or not a trespass even occurred. And that's the reason why we believe a declaratory judgment would be appropriate, Your Honor.
Do you have any case law to support this position?
Yes, Your Honor. Pulling it up. Your Honor, if I may, what's the case that opposing counsel referenced in the Fifth Circuit Court that the opposing counsel referenced in his response? Because I'm not seeing it in this one.
Dallas Court of Appeals.
Yes. That's the Armstrong DLO properties. It's Mr. Lazaton, if you will look at our motion, all of the citations are included in footnote 4 on page 5.
Yeah.
DLO is a 2015 Westlaw 265653.
Hey, 1 second.
He's here with me. Okay. I mean, is there a difference in this case on this issue because there was an encroachment on the property? Was this the one with the little piece of concrete
Triangle, yes, Your Honor.
underneath the fence? Was that this case?
Yes, Your Honor.
So does that change the analysis? Because it's not simply a title dispute, there's an actual trespass that occurred. Is that allow there to be, is there cases that allow that for attorney's fees?
Well, Your Honor, the case law that we provided, I mean, none of the case law that opposing counsel provided dealt with a boundary dispute. Not quite sure how the case law that's cited is applicable here, because that isn't the case. I mean, the reason why we were pushing for a declaratory judgment is because we needed the line defined first before we could even look at the trespass. And it wasn't as simple as trying to prove up ownership as required under element 1. We need the line defined so that we could figure out what the trespass was to begin with. And Your Honor, that's how I believe that we differentiate ourselves from case law. I'm pulling up. Yes,
Response?
faster way to do this.
Your Honor, first, with respect to trespass, attorney's fees are not recoverable. It's a tort. So the only way they're going to get to attorney's fees is under the Declaratory Judgment Act. And if it involves questions of title, the Supreme Court of the Dallas Court of Appeals has made it clear that you cannot use the declaratory judgment statute as a vehicle for recovering attorney's fees. In this case, as I said before, the survey says that the plot does not mathematically close. He's doing it based on what he finds on the ground. That's not interpreting the deed. That's not saying this is what the deed says. You have a surveyor saying, this is what I found on the ground. In fact, if you look, it even says, you can do further title search, you can do title examination. I'm not making a judgment on those. That's in that very same exhibit as well. He necessarily was determining title when he drew the lines. It's not a simple boundary dispute. It now questions that they have the right to title, which supports the trespass claim. They're entitled to their judgment on that claim, Judge, but not attorney's fees.
I'm going to grant the motion of reconsideration in part. I'm going to reconsider my award of attorney's fees based on the argument before me. I know you submitted an order, Mr. Odenz. I think it was a little broad, and so I want you to work with Mr. Lazatin about this and give me a proposed order as soon as you can by no later than this Friday. And make sure at the beginning of the order, it says that on February 6, 2023, that the court heard this and set up on this date.
Well,
all right, guys, thank you very much.
Your Honor, does this, since this is a motion for reconsideration, does this just open this up to where we need to reset for trial? Because we're scheduled for trial, I think, at the end of the month. I mean, this is.
All it does is it takes away the attorney's fees award, but otherwise the judgment is still good.
Well, Your Honor, there's case law where in a boundary dispute case, attorney's fees were awarded. That's what I was looking for here while opposing counsel was speaking. It's a Court of Appeals case in El Paso, 2021.
I've heard argument on this.
I'll work with Mr. Lazaton on a proposed order and get it to the court, Your Honor.
Thank you, guys. You have a great rest of your day, okay?
Thank you.
All right, guys, I'm gonna take a quick break and I'll be back with you in a few minutes. Okay, guys, our next hearing is on the Cactus Power and Light versus United Rentals, Inc. case DC 223371. Are both sides here on that?
Your Honor, I'm here, David Nelson for the plaintiff. I'm having camera technological issues, but I'm good by voice, if that's okay for the court.
Okay, so you don't you have your name as, assume your same name is not iPhone, correct?
That is not iPhone. My computer is not helping me.
Okay,
Is it okay?
it's not ideal, but we will make do. Who's the other side here? And you're Mr. Bobby, you are muted or something. We can't hear you. Your sound may be off because you don't look like you're muted. It's just, we can't hear you.
And also, Judge, what case is this? I'm sorry.
It is DC 223371 Cactus Power and Light versus United Rentals, Inc. All right, Mr. Arbabi, is Mr. Arbabi your opposing counsel, Mr. Nelson?
Yes, it is. Yes, Your Honor.
Mr. Arbabi, now we can't see you either.
You have one voice and, oh, you can't see either, huh?
I can't see you and I can't hear him or see him. All right, why don't we skip you guys until you get your tech issues out, and we will, he's okay, apparently we are both sides here for the NZ versus Geico Casualty Company.
Defendant is here, Your Honor.
Hi, plaintiff is here.
All right, let's go on the record on DC 22-13842 NZ versus Geico Casualty Company. Counsel, make your appearances.
My name is Uchachi Yamaneke Nze. I'm appearing pro se from the plaintiff for myself.
And Kelly Crane here for the defendants.
Mark Tyser, Your Honor, for Melanie Perry, personal counsel.
Melanie Perry, okay. Explain what your role is, Mr. Tyser.
I'm a personal counsel. Mr. Crane is a hired counsel from the insurance company.
Okay, let's go forward. I think it's your motion, Ms. Lindsay.
Yes, okay, thank you. My sanctions for, I filed a motion for sanctions against attorney Kelly Crane and Geico, just for their response for my motions for summary judgment regarding Geico's breach of contract. And it's very simple. So that motion for summary judgment was just about Geico breaching the contract because they did not pay the claim within 5 days of accepting the claim, which is in their, sorry, not pay the claim, but pay me within 5 days of accepting the claim. And since Mr. Crane has had in his possession evidence that proved that inexplicably, undisputably proved that Geico, in fact, did not pay the claim within 5 days of accepting it. And that's what's shown in his response to that motion. So if I could show you, just share my screen, is that okay?
Sure.
Okay. Okay. I just wanted to show you, this is just my reply brief in response to the motion, which was filed today. But it just breaks down my argument a little bit more simply. Okay, so the part of the contract that is that Geico breached says if we notify you, we'll pay your claim within, or part of your claim, we must pay within 5 business days after we notify you. And defense counsel claims submitted an affidavit and declaration from their custodian of records, Allison Cunningham, that actually very much agreed with that undisputed part of my claim. And in the declaration, which is Exhibit C, in the declaration, Allison says that, yes, in fact, I did not, that Geico sent an uncertified check to me, and that check was never cashed. And since that check was never cashed, that means that the payment was never actually made for the claim for any payment within that 5-day deadline. And that was what I was saying was breached within that contract. And
Are you saying that if they send you a check, I know you have a dispute on whether or not it's the right amount, but if they send you a check and you don't cash it, then that means that they're in violation of the Prompt Payment Act?
Yes. Well, not for prompt payment. This is about breach of contract.
Okay.
So for this, and that's due to Supreme Court ruling in Underwriters Insurance Company versus Tex-Mex Inc. The Supreme Court concluded that mailing a check constitutes a tender of payment, but tender is it's not actually a payment. And that tender of payment, that check that they sent, wasn't for the amount of the claim. It was for some arbitrary amount that I never agreed to. And so since they sent an uncertified check, isn't a conditional offer, and for a certified check to constitute a payment, it says the check must be both accepted and honored. And that's, there's the little reference for that. And that's also reaffirmed in Sonny Latote versus United Services Automobile Insurance Association. That was in the Court of Appeals in the 15th District, I think. Or sorry, the 5th District of Texas. And they concluded that USAA did not establish that they paid a claim on Latote's vehicle. The court found that because Latote returned the check, USA did not, in fact, transfer any funds, and it did not constitute a payment for that claim. And so in this case, because Geico did not actually transfer any funds with the check that they sent, that did not constitute a payment within the time frame. And that's just pretty simple. Let's see. So yeah. So, and this motion for sanctions, which is, what this hearing is about. This motion was because Attorney Klain and Geico have had that information that I never cashed, or honestly could cash the check that they sent within the 5-day deadline. And they knew that. However, they still disputed my breach of contract claim, even though there's no dispute that payment was never made. So that's the argument that I'm making and why I'm filing for these sanctions.
Response?
Yes, Your Honor. The plaintiff filed a motion for summary judgment without any admissible evidence. I filed a response with admissible evidence supported by affidavit testimony and documentation that proves my case. It also disproves the plaintiff's motion. And essentially, I think what the plaintiff is saying is what you said, Judge, that just because she got the check and didn't cash it, I guess she's saying that is not a payment and it is not in compliance with the Texas prompt payment statute. The cases she cited, I've only had a chance to review a couple of them because this response brief was filed about an hour ago. They're inapplicable. The Texas Supreme Court case that's called Texas Mutual, it's a banking case and it has to do with paying for a life insurance premium that ultimately was dishonored by the bank. It has no application whatsoever to our situation. But again, I guess what I would point the court to today is she's seeking to sanction me and Geico for filing a proper response to a summary judgment, and I can only ask that the court deny that.
Mr. Tyser?
Your Honor, pro se people are held to the same standard as lawyers. We don't make exceptions to that. And this latest motion is another example of, Your Honor, no basis in law and fact, nothing to say court time and try to sanction Mr. Crane, who, by the way, 99.9% of the time, he's on the opposite side of me. Okay. We're on the opposite side. But I'll tell you one thing about Kelly Crane. If you can't get along with Kelly Crane, then the other person has a personality problem, because this guy is as good as gold. There is no sanctionable behavior for disputing that. The Tex-Mex case, the court knows that most of my practice is devoted to insurance. The Tex-Mex case cited is for the proposition of pay any undisputed amount, which is exactly what Geico did. The fact that it later becomes disputed and later is not. And can you imagine what games could be played if somebody said, well, you sent me the check and I didn't cash it, so therefore there was no tender. Well, or no payment. But under the prompt pay statute, the issuance of the payment within 5 days complied with the statute as the evidence reflects. This court has many cases, and this court is one of the hardest working courts in Dallas County. No question about it. I've reviewed all of the things filed to date, and my suggestion is that this case be put on hold until Mr. Crane's 91A motion is decided, before we waste a lot more time and money on motions and filings and other things that have no basis in law and fact, because perhaps the plaintiff doesn't realize that she too can be sanctioned for filing for pleadings without a basis in law and fact, or simply for purposes of delay and harassment under Chapter 10. And there is no bad faith. There is no sanctionable behavior. There is nothing but a dispute between the plaintiff and Geico, I assume, about how much money is owed. And she's certainly entirely privileged to litigate that. But what she's not privileged to do is sue all of these people, including 2 lawyers that represent Geico. Facially, that is sanctionable. There is no allegations that would fall that would allow them to sue opposing counsel on this, and perhaps, and also what I reviewed as to the adjusters. But this motion should be denied. And graciously, Mr. Crane has not filed a corresponding motion to recover his fees, nor have I done it for mine, and ask the court put this case on hold until the 91A motion is set, which I think is sometime in a couple of weeks, before the court wastes a lot more time. If it's valuable and limited resources to adjudicate that, and I think at the end of the day, the court's going to be left with a dispute between the plaintiff and Geico about money owed, which is certainly fine, and the plaintiff is certainly free to litigate pro se on her own. But she is held to the same standards, Your Honor. There is no exemption for pro se people because they don't know the law and start suing lawyers and other people without basis in law and fact. And this motion is just one of them. This court has always been gracious to all litigants and treat them with dignity and respect. And nobody has sought any sanctions on this motion, but the 91A is coming up. And I asked the court to consider staying this case in its entirety until that motion is heard, so you can sort out what really this case is about, rather than wasting everybody's time and effort, and most of all, the court's limited and valuable resources. I thank the court for its time.
All right.
May I, Your Honor?
Let me just say this.
Mhm.
I'm really trying to be paid. I think you're a very nice person. I sympathize with your frustration, although I think I've done my best to try to explain this. I think Mr. Crane has as well. But Mr. Ticer is right that you are held to the same standard as an attorney, and if an attorney was doing the things that you're doing, I would probably sanction them.
Well, but have I done incorrectly? Because I mean, I don't want to do anything to offend anybody. I just have gone by what the law has said. Yeah, and that's the only reason why I'm filing these sanctions. This is from like Lowe versus Henry. The Supreme Court of Texas found that Henry's conduct was sanctionable because he obtained directed review of evidence that disproved an allegation or factual contention, yet still decided to sign this groundless pleading.
Okay.
If Mr. Crane can honestly say that, yes, when they sent the check for $1,600, that was the amount of the claim, a claim amount. It wasn't the amount of the claim of my loss of use claim. And that's actually that he actually in his response proved that it wasn't the claim amount. The claim amount was for $3,000, not for $1,600. So no, they didn't pay the claim at all. First, they didn't pay the claim, period, didn't pay me because I didn't accept a check that was less than what the claim was actually worth. And that's just, I mean, that's what the case is about. And I don't know this new attorney that's actually here for Ms. Perry. I've never seen any kind of documentation that she actually has personal counsel. This is the first time I'm actually having any kind of, I've never seen this person, or he's never been a part of this case before until this moment. So I don't know where he's coming from, or if he's even allowed to speak right now, because he's not been a part of the case. And when I sent documentation, when I served my documents this morning, he wasn't listed as an attorney for Miss Perry. So I don't know why he's here and who he is. Mr. Crane, yeah, I do know, but the other person I don't. And so that's all I'm saying is like, I am abiding by the law by filing this motion for sanctions because
Stop.
Yeah, I have not done anything wrong.
Okay, let me go ahead and speak. You keep interrupting me, so I'm going to mute you. So, ma'am, you're not following. I know you're trying. You're actually doing. You really are trying. I was talking to another one of the judges here who's very experienced, and he gave a good example. I guess I'll try to give it. I don't know how else to communicate this to you. Is that, you know, I'm a very experienced lawyer, but I wouldn't perform surgery on my own arm. You know, I wouldn't try to do the taxes for a major corporation because I'm not an accountant. You're not an attorney. You're doing a good job of trying to do the research here, but this stuff is very complicated. I would urge you to try to get an attorney here. You're wrong on the law on this again, and I'm trying to be nice to you, but at this point, I'm going to deny the sanctions. And Mr. Kaiser is right. At some point, I'm going to have to start, if you keep filing these frivolous motions, I'm going to have to go ahead and sanction you. I don't want to do that. I urge you to get an attorney to talk to you. You're simply not correct on the law. And I'm trying to be as respectful as I possibly can, but you're just misinterpreting the law. I don't think you're trying to be malicious about it, but Mr. Crane has done nothing sanctionable in this case. Neither is Geico. I'm going to deny the motion for sanctions, and I would urge you once again, before this keeps going down the route it is, that, and I don't think you're going to listen to me. I hope you will.
I just have a question.
Okay, go ahead and ask a question.
So is this considered payment that was not cashed? Was that considered a payment?
I think this qualifies under the statute. They sent you a check.
That's so illegally though. I didn't see any case law that said that constituted a payment for anything. If it's not honored and it's not accepted, then that does not I didn't see any case law that said mailing a check is actually considered payment. There was nothing that I saw. There's no case.
I can help a little bit. The Tex-Mex case that she cites is a case where there was a dispute about the total amount owed, and rather than not paying anything, the insurer paid something, what they considered the undisputed amount, and then they could fight, in essence, about the rest of it. And the reason they did that is because the statute was designed for somebody to pay the undisputed amount. So Geico's paying some amount that they say they don't dispute that amount. It may not be the full amount, and by accepting that
Excuse me.
check.
Sorry, excuse me, Your Honor. I literally have no idea who this person is, and they're taking up all my time during my motion and my hearing.
I filed an
It's
entry
really
of
like-
appearance, ma'am.
It's
I
like,
filed an
so-
entry of appearance to this case.
and I never saw that. And so it's like, it's kind of like annoying because he's taken a lot of time, and it's like upsetting me right now because like because no one's presented case law that says that just mailing a check considers payment. There's no case law to substantiate that. So if someone can literally come up with case law that says, oh yeah, mailing a check to someone is considered payment, doesn't matter the amount, is considered payment, then I'll be fine. That's right. But no one has said anything so far.
You're a very bright person. I think you really consider going to law school because I think you are, you're doing a lot of research here. You're wrong on the law on this. I don't know what else to say. Motion for sanctions denied. It's not even a motion. They're going to be asking for attorney's fees against you. This is just going to keep getting worse. I urge you to please stop and talk to an attorney about this and maybe listen to them, because you're not listening to me. You're not listening to anyone else. But I wish you the best of luck, guys. The motion for sanctions denied. Have you submitted an order on this, Mr. Crane?
Judge, if I have not, I'll submit it this afternoon. I think I have, but I'll double check.
Let me just. Guys, have a great rest of the day, okay?
Thank you for your time, Your Honor.
Thank you, Your Honor.
Okay, you guys on the cactus case, have you guys worked out your technology issues?
I think so. Can you hear me, Your Honor?
Who's that, Mr.
This is Nader Arbabi for the defendant.
Mr.
Okay,
Nelson.
great.
Your Honor, I'm on as well. David Nelson for the plaintiff.
Okay, so let's go ahead and proceed. Let's go on the record, Tony, on DC 223371. Counsel, make your appearances.
David Nelson
Nader-
for the plaintiff.
Nader Arbabi for defendant United Rentals. And on the record, I'll go ahead and say that sounds like David. We've had a few hearings and depositions, so I know his name is iPhone. But this is my motion, so I'll go ahead and start if
Go ahead.
all right. So defendant filed this motion for continuance for basically for additional time to develop the facts and investigate the claim that plaintiff is making. Originally, plaintiff had filed this suit in March 28th, I believe, of 2022 of last year. So the case is less than 1 year old. On December 21st, just at the end of last year, maybe just over a month, maybe 2 months ago, defendant timely responded to plaintiff's first discovery request, and during that process, defendant kind of became clear that defendant did not have access to all the information, the responsive information potentially that it needed to respond. United Rentals, the defendant, is a national company, and a lot of these documents that plaintiff was requesting are stored in Iron Mountain storage, I guess a third-party storage facility. At that time, defendant, I reached out, I conferenced with plaintiff's counsel about the need for a continuous motion as discovery ends at the end of this month. Plaintiff's counsel initially seemed to be agreeable as we worked together to set a new agreed scheduling order in place. And then at some point during this conferencing, plaintiff's counsel was no longer agreeable to a continuance, saying that I believe his client would have preferred discussing settlement as opposed to continuing discovery. Defendant's position is that we're not in a position right now to, I'm sorry.
Don't worry about it.
Yeah, to discuss settlement or anything. We need a bit more time for discovery. We conducted the deposition of plaintiff's corporate representative on January 20th. During that time, it was discovered that another corporate representative depot might need to be taken. To give you a little bit of background information on the case, it is a suit for Cactus Power.
Let me hear from
Go
you.
ahead.
I've read your stuff. I just don't know. Let me hear from you.
Gotcha. Yes, sir.
Your Honor, The dates that he has given you are pretty much accurate. He's had ample time to perform his discovery. The first discovery was one that was not even on focus to our case. I guess it got out by accident. We started over. He is not correct, Your Honor, in saying that I was ever agreeable to making any changes. He asked about making some changes to the scheduling order, and I said, what changes do you have in mind? And he sent back a change to every date on the order that has been signed by you some time ago. And we encouraged him to take whatever depositions. This was in December, and then again, and he said he had no time in January, but he did do the deposition of the main principal for our side in January. We provided him with an affidavit of a former employee who is agreeing with our presentation of the case. I don't know how he hasn't asked me or the plaintiff for anything related to a dispute of what was said in that affidavit, nor do I have any idea that he may take the deposition of that person. He hasn't said that either. There's really not a good basis for continuing the scheduling order as it's signed and been in place for some time.
Mr. Nelson. Mr. Nelson.
Yes, sir.
This is a 2020
Yes,
case. Fortunately, I haven't reached a single 22 case yet. I mean, we are still backlogged from COVID. We're trying to dig out. We're working hard and trying cases, doing everything we can, but it's a 2022 case. When is it set for trial again?
April the 11th,
Yeah,
2023.
The chances you guys are going to get reached at that point are virtually zero. Let me just kind of take a look at this. Yeah, it's a jury trial, first trial setting, 2022 case. You're just not going to get reached. So just from a practical, and I will tell you that in 98% of cases on a first trial setting, I'm going to give a continuance, unless, is this a level 1 case?
No, sir, level 2.
So yeah, I mean, occasionally on level 1 cases, I'll go ahead and, you know, I sometimes won't continue those because of the way the statutes or the rules are written, but I think we're all kind of wasting time.
Your Honor, may I ask the court to order mediation?
Sure. I haven't ordered it already.
Well, you've indicated that we must have it by a certain date, but I would like to suggest that we have that in the month of.
Yeah, I have no problem with that whatsoever. Who do y'all want to use as a mediator?
Well, I believe that I don't have that name here, but I think you have a name that you recommended, and we've been in contact with that party.
Do you know who
I
that?
apologize.
Mr.
I don't see that name on the signed order.
Let me see. We usually do send out a mediator. Yeah, it's right here. Ken Rubenstein.
Yeah.
Is that on Parrot? Where is that?
Is that
That's
what?
the name I remember.
I was just wondering if I'm missing this on the scheduling order.
It's on August 11th. We sent you a mediation order.
I would suggest, Your Honor, we just stay with that mediation date, which is no later than March the 10th. And I don't mind moving the trial date. I wouldn't like to move it very far, whatever your recommendation is from the court. But at most, one more month on discovery. It just seems like this thing is, there wasn't any discovery. The discovery was wrong to start with. I encouraged him I responded timely to everything, and he has too. He's added to his discovery once. He added 3 more interrogatories. I responded to those. It seems like certainly we're ready for mediation. I would like not to extend that.
May I respond, Your Honor?
Sure.
I'd object to the the March 10th mediation, I would be agreeable to if we get a continuance granted, I'd be agreeable to an earlier mediation that is in our proposed scheduling order that we filed with our motion. But I would say that March 10th is a bit too soon, just because we do have more responsive, potentially discovery to supplement with. I would think that he would want all the discovery as well, so we have a productive mediation as opposed to just going there and going through the motions. So I would, I'd be agreeable to April or May, but I think March is a bit too soon.
Your Honor, I want to be agreeable to what is necessary to bring this case to a completion. We wouldn't have filed the case if we didn't have the evidence we needed to win the case. He's not tapping into that evidence in a way that I would have expected, but I'm happy to help, and that's how I would view it. So if we can go ahead and order mediation at a certain date right now,
or a certain time,
yeah, it's down for March 10th. Let's just go to the end of March.
Let me look at this real quick. So this is going to be, you guys want a jury, right? So
I don't need a jury. He asked for jury trial.
Which I'm not trying to criticize anyone. It affects when I can set it. So I'm thinking maybe August 15th if you want a jury trial, or August 22nd or August 29th or something like that.
Sure.
Sooner the better, Your Honor.
I believe that's the date in our proposed scheduling order as well that we filed with our motion. Around there, I think it is. Yeah, August 14th is in our proposed scheduling order.
All right, so we try cases on Tuesday, so we schedule this for August 15th and 2023 at 9 a.m. Mediation will be ordered to take place by May 1st. So you'll need to reach out to Mr. Rubenstein's office at Burden Mediation. Soon.
Yes, Your Honor.
Anything else, guys?
Should I submit a new, I'll get with plaintiffs. I'm sorry.
I've already done it. I've already signed everything.
Okay, great.
Don't need to worry about it. Okay, guys, have a great rest of your day.
Thank you, Your Honor.
Thank you, Your Honor.
Bye-bye.
Okay, our next order is I believe is Hill and Wilkinson Construction Group versus CC Memorial Homes. Are all sides here on that?
Yes, Your Honor, looks like it. Several folks. I represent the defendant and counter plaintiff, CC Young.
Okay, all right. So Tony, let's go on the record on cause number D20111514. Wilkinson Construction Group versus CC Young Memorial Home. Counsel, make your appearances.
Michael Gavito here for the defendant, movement today, and counter plaintiff, CC Young.
John Slates for plaintiff Hill and Wilkinson.
Pat Mulry for Prism Electric.
Larry Johnson and Virginia Cox for D2 Architecture.
Gary Inman on behalf of Polk Mechanical Company.
And Reese Wade for T Texas Sprinkler LP, doing business as Texas Sprinkler Company.
And John Sheaf, co-counsel for CC Young Memorial Home.
Great. Let's proceed.
Yes, Your Honor. Michael Gavito again for the movement. This is it's a motion for continuance. We're set for trial on a bench trial for February 21st, 2023. This case involves a claim by Hill and Wilkinson against our client, CC Young. It started off as a payment dispute. Our Our client has counterclaimed for defective work, and they also have a claim pending against Hill and Wilkinson. We've also added a third-party claim against the project architect, that's D2 Architecture. The other folks here represent a couple of the subcontractors that had payment disputes with Hill and Wilkinson and CC Young, and they had separate lawsuits pending in Dallas County, and those have since been consolidated with our case. So the project at issue is a CCRC. It's a continuing care retirement community that houses the elderly, has an independent living component along with an assisted living and memory care unit to help folks as they transition into the older years and need the medical care. So we've been engaging in discovery. These cases involve a lot of documents and are very expert intensive. In about November of last year, we got Hill and Wilkinson's supplemental document production, and we had issues trying to access that for a couple of months. The size of the files were significant. Ultimately, we did engage with Hill and Wilkinson's contractor, their IT contractor that was helping them with the documents, to help us unravel the password protected documents. And when we finally got them into our document management software, that's when we understood the volume of what we were getting. And it was something in the neighborhood of 155,000 documents totaling 389,000 plus pages. We're in the process of getting our arms around that data. Meanwhile, in September of last year, because we were waiting on confirmation of search terms and how we would be searching on our side for our clients' emails from Hill and Wilkinson's counsel, when we finally got all that started in September of last year, our client sent us a hard drive with what we understood to be all of the emails that were relevant and responsive. Well, we tried to open those and they had an error. And so then we got back with our client. They engaged an outside IT person. Finally, we got these emails uploaded to our server in December of 2022, December 21st to be exact. And when we finally got the files into our server, we realized that what the client had pulled was 206,000 documents totaling over 558,000 pages of material. So we currently have 4 lawyers at our office that are spending a significant amount of their time going over our clients' emails to make sure that nothing privileged is inadvertently produced. Now, there are going to be a lot of privileged communications in this file as compared to others because both sides, CC Young and Hill and Wilkinson, were represented by counsel towards the tail end of the project, and lawyers were involved for both sides, attending owner, architect, contractor meetings at the tail end of the project. And so there's going to be a lot of communications that will have the names of lawyers on them, but will also at the same time also have side communications that are protected by the attorney-client. And so in addition to where we are in the documents, none of the experts have been deposed. In late December, I sent an email to confer on this motion to Hill and Wilkinson and all the other parties. To date, I've not heard a response from Hill and Wilkinson on whether they oppose it or don't oppose it. I've also sent out some requests for depositions of Hill and Wilkinson's experts and a corporate representative. And I also sent a request to D2 for their experts and a corporate representative. And I provided topics to both sides. And D2 responded and they said they can't get me a representative in the near future because of their conflicts. And D2 does not oppose this motion. They told me that. So I'll defer to them on what they can get me in terms of depositions and when, but we're trying to move the case along, but we are where we are, Your Honor.
Response?
Your Honor, John Slates on behalf of Hill and Wilkinson. We recognize that as a practical matter, the case isn't ready to go to trial. There is much more work to be done in this document. Situation has truly been a challenge for all of us. We still don't have any of the documents from Mr. Gavito's client. As he said, they're still in the process of a privilege review. I think the request and the continuance is for a 6-month continuance. We would just like to be sure that whatever order gets entered, that the scheduling order that accompanies it is very detailed in its requirements. It relates to when the owner will produce its documents and other issues as well. So we're not opposed to the continuance in the sense that that we think it's not justified. We're just frustrated with where the case is, given how long it's been on file and the fact that my client believes it's owed $5.2 million.
Anybody else have an opinion? Anybody, Mr. Mulroy or Mr. Allemon, anybody want to say anything? Ms. Cox, Mr. Johnson?
Your Honor, that we represent D2. We're not opposed to the motion. We have been working to identify corporate representatives that have been requested, and we're trying to find dates for them. Ms. Cox and I were set for a trial in Harris County that was supposed to start today. It got continued late last week, so we now are turning to this to try to find information. We also have some supplemental document production that we're working on in response to some discovery requests that were sent to us. So we agree the case is not ready, and so we're not opposed to the continuing.
So I guess this case was filed way back in 2020. It's almost 2.5 years old. I mean, what has been the delay? Why has this taken so long you haven't done any depositions, it sounds like, or any expert depositions?
No, Your Honor, that's correct. And I believe the bottleneck has been on the volume of project documents for not just our side, but also Hill and Wilkinson. They're massive, massive documents to productions from both sides. And until we get that out on the table, that's really where the experts and the key documents exist to cross-examine witnesses in these types of cases.
But if this was a 2022 case, I'd gladly continue it. A 2021 case, I'd be not thrilled, but my only concern is a 2020 case, and there's still no depositions. Would it be better just to get this case tried? I mean, just get it the old-fashioned way. Some of you guys, Mr. Sheep, you've been around a long time. You guys used to try cases like this. I used to try cases like this, team up and get them done. I'm just concerned at the age of this that there's no deposition. Sometimes, you have back burner cases that you feel like, this isn't, I don't want to put as much resources into this case because I have another case I think that is deserves more time. It's just, this is a pretty old case to have no deposition. I mean, it's a very old case to have no depositions. And I worry if I move it, that it's not going to, will just be the same place in 3 months or 2 months or 4 months or whatever we do. Maybe we just, Mr. Sheep, what do you think? Why don't we just try this?
I think, Your Honor, this case has been one where the parties have worked to try and share the documents between them in order to move the case. This is not a case where people have sat back and just delayed the case in any way. These types
with a lot of documents. I mean, I know your firm, you guys, I mean, it's not unusual in this day and age to have a lot of documents. It is unusual to have a case that's 2.5 years old that doesn't have any depositions.
Well, I understand that, Your Honor, but I think the magnitude of the documents and the issues with respect to getting the documents accessible to all the parties has been problematic for both sides. I do think everybody feels that they're to the point now where we believe the documents will be able to be produced fairly soon, and we can move forward with all the depositions in the case.
Your Honor, if I may, our experts can be deposed the week of February 20th. I had them holding that week, and I can present all of CCM's experts that week.
The other thing, Your Honor, that I'm not sure you're aware of is that everybody except us and the owner got joined to the case last year. So everyone wasn't at the party, so to speak, from the get-go.
You know what? I feel more comfortable if you guys had more of a plan here. I'm not 100%. I mean, in all likelihood, I'll continue it. I want to know exactly what your plan is. Like, for example, Mr. Gavita, you said that you've given dates to take depositions. It sounds like those haven't been taken. I just need to figure out, is this a case where because I've had a lot of them where, I give a continuance and I give another continuance, and I give another continuance, and nothing ever gets done. I want to have a scheduling order in place that says exactly when things are going to happen and how they're going to happen, so that I know that this case is going to move forward, and that doesn't happen yet. So what I would suggest is maybe you guys meet this week, kind of figure that out, get a very detailed detailed scheduling order, all the depositions scheduled. We'll reconvene next Monday, and then we can kind of figure out what would be a reasonable trial setting. I don't want to just, this case, if this case was a 2022 case like the last one, I'd be happy to just kick it down the road. We are really working very, very hard to try all our 2019 and 2020 cases right now. So you guys are kind of, I don't know for sure that you're number one, but you're going to be close to be number one and on the 21st. And we need if we're going to move you, I want to know that there's a plan. So does that work for you guys to redo this on Monday, or should I just deny the continuance? Do you feel like?
Your Honor, no problem conferring. I can send out a Zoom information to all the lawyers and give dates for our folks and have something solid.
You guys in a break, and I'm also not opposed to put you into a breakout room and you guys hash this all out, come up with an exact scheduling order and come back in, if that would be easier since you're all here.
Sure.
What do you think, Mr. Slade? You seem concerned about that.
No, I just think in terms of needing to coordinate with clients to determine dates, it might be more productive if we did this offline after coordinating with the witnesses that need to be deposed.
Okay. All right. Can you go get Rhonda real quick? Rhonda, are you there? Let's get, is this, I don't know if you guys are you guys all local? Do you guys prefer to do this in person or remotely? I can reset this the next Monday at 3:30 and we can do it remotely.
That works for me.
Does that work for everybody?
Yes, Your Honor.
Yes, Your Honor.
Yes, Your Honor.
Mr. Alaman didn't respond, I don't think.
He may have audio issues, Your Honor. He's here for Hill and Wilkinson as well. They have two sets of lawyers.
Okay, sorry, I just want to make sure. All right, so we'll reset this motion for continuance. If you could get me a very detailed scheduling order with all the depositions included, all that kind of stuff in it by next Monday with a reasonable trial date as well that you guys can agree on. I'll be glad to take a look at it. Can you go ahead and reset the motion on this 2020 case? It's going to be heard next Monday at 3:30.
Your Honor, can you give us an idea of what your bench trial weeks are in that 6-month time frame?
Well, sorry, it is DC 20-11514. Is this a case where we have a jury waiver, or is this going to remain a non-jury case?
As of now, Your Honor, I believe so.
I'm just wondering, do I put this on a, so one of the things that has changed post-COVID, that's good. One of the things that changed post-COVID, for those of you who've been around a while, we used to have 10 to 12 non-jury weeks every year, and I would always set cases that are non-jury onto non-jury weeks. Because we were trying non-jury cases, but not jury cases. The decision was made by the judicial leadership here, and I fully support it, is they cut way back on the number of non-jury weeks. So the only one in the next 6 weeks, essentially, or 6 months, is March 14th. I don't know that helps you a lot. And then the other weeks we have that are non-jury are the week of July 4th, thanks Christmas, or 2 weeks of Christmas. So
Judge, you were kind of breaking up there. It was hard to hear.
Oh, I'm sorry. So there's really not any non-jury weeks other than spring break, I think, that would really, but I don't know that gives you enough time. And so there isn't a great time to tell you, unfortunately. They just don't have any non-jury weeks because we're trying to try as many cases as we can. So I would just pick a date. I'll let you know. You to see how you look on that week, and then we'll see this next Monday. You guys have any questions?
No, Your Honor.
Okay.
No, Your Honor. Thank you.
See you guys next Monday, and good luck, and we'll see you then.
Thank you, Judge.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
And this will be remote. All right, next case we have is C21. I think both sides are here. 2520 Segovia versus Merca. Are all sides?
Your Honor, Robert Vengro for the plaintiff.
Greg Scott for Irving Holdings. John House is here too.
John House is here. Is he here on this case, John House?
Yes, Judge.
Mr. House, are you there? Mr. House is he's muted and his camera's off. I hear somebody has a TV on or something. Is that y'all?
Oh, Your Honor.
Who's Melissa Allison? Is she on your case?
No.
Mr. House, you need to go ahead and unmute, please. Is he part of the fight here, or can we go forward without him?
Definitely part of the fight.
Yeah, he's the smallest. He is part of the fight.
Judge, can you hear me now? Hello?
Yes, we can hear you now.
I'm sorry. I'm doing this on my phone. It's my first Zoom on my phone. I'm trying to figure out how to get the camera unmuted.
Okay. Let's go ahead and go forward.
Your Honor, if I may.
Yes, please.
We are here today on plaintiff's first supplemental motion to compel depositions of 2 corporate representatives and 2 fact witnesses from the defendants. Before I proceed, I would like you to know that as far as the 2 corporate representatives, we have dates for them and they are scheduled for this Thursday. So the compel is only going to be in regards to Sergeant Quiroga and W. Shemek. Now, as far as those 2 witnesses, Mr. House has provided us dates for Sergeant Quiroga, but they're not until after the trial setting on this matter. We've had issues with scheduling because Mr. Scott and Mr. House cannot get on the same page due to their schedules. I guess they're quite busy, and that's why we haven't been able to get that set before the trial setting. But we have been requesting that deposition since the beginning of November last year. This is a case that was filed in February of 21. We have taken the deposition of the driver involved in this case, but all of the other depositions have been delayed. As far as W. Shemek, plaintiff believes that that person is somebody involved with Irving Holdings. And the reason for that is in the motion in the attached exhibit A on page 21 of the entire motion, there is a portion of a DART incident report review that was done by Detective Vanessa Robles, where she is looking to get the information of the driver that was involved in this case in her investigation. She reached out to somebody named Hawkins, and Hawkins reached out and stated that Hawkins asked W. Shemek to provide the driver's contact information. Hawkins stated that the taxi vehicles for Irving Holdings do not have cameras. W. Shemek responded and provided driver's information to B, and then gave the defendant driver in this case's information. So we believe that W. Shemek is most likely involved with Irving Holdings, given that he's the person given the information for their driver, but he could be involved with DART. To date, both Mr. Scott and Mr. House have said they have no idea who this person is. So we have not gotten any dates at all for Mr. Shemek, and we believe that that is not proper, that somebody knows who he is. And the final thing that I would mention to Your Honor, I have multiple other exhibits that I've attached to this motion. And just to let Your Honor know of the issues that plaintiff has been having, particularly when it comes to defendants Irving Holdings and Tadel Burka. We have had nonstop issues both with discovery and deposition issues in this case. We've had multiple hearings, we've had multiple motions, and it is our belief that Greg Scott is the reason why we do not have dates for this person. Mr. Scott has been very combative during this litigation. He has not been willing to provide dates when requested, and he's drug his feet and delayed everything when we have asked for dates. He has also been, in my opinion, his conduct has been unbecoming an officer of this court. We had a hearing with Judge Merritt back in December, Mr. Scott was not happy with the way that hearing was held. And when Mr. Scott responded to our discovery, he included a note that says, as requested by Judge Merritt at the December 2nd discovery hearing, parentheticals, which was a waste of time. Your law firm is hereby served with the following. So at this point, it's really difficult for plaintiff to know if these two attorneys do not know who this person is, or if they are just purposefully trying to frustrate the discovery process because they are just, at least as far as Mr. Scott, he is just over this case and he does not want to be doing anything moving forward. So plaintiff requests that His Honor compel and order the two defendants that we have here today to provide dates for both Sergeant Quiroga and W. Shemek within 7 days and within a timeline that the depositions can be conducted before the trial on April 4th, 2023. Thank you, Your Honor.
Response?
Mr. House, would you like to go first?
Yeah, that's fine. Can you hear me, Judge? I'm sorry. Thank you. I have, over the last 2 months, been dealing with some familial issues. I put my mother in the hospital on November 22nd of this last year. And basically from then until January 15th, she was hospitalized and ultimately died back on the 15th. We had her funeral on the 22nd. Now, I candidly admit maybe I haven't been as responsive to deposition dates as I could have been during that time frame. But the only excuse I have for you is that my attention was taking care of my mother and dealing with the end of life issues associated with her. In terms of Sergeant Quiroga, I did provide dates for him. One of those dates that was provided was February the 9th. I also offered to tender the DART corporate representative at that time. I was told by Mr. Van Gro that he didn't think he had adequate opportunity or time to take both Irving Holdings corporate rep and DART's corporate rep on the same day and wanted additional dates, and additional dates were thrown out. However, those dates, the only two that are available are March 24th and March 31st. Notwithstanding the fact that he said he couldn't take the DART corporate representative on the 9th, he went ahead and noticed it on the 9th, and we're prepared to move forward on that. W. Shemek is this other person that he wants to work, doesn't work for DART. I verified that he doesn't work for DART. Only Sergeant Quiroga works for DART. So I don't know what he wants me to do with Shemek.
Is there a way to get Sergeant Quiroga's, how do you spell that?
I think it's Quiroga, I believe.
Is there a way to get that deposition sooner, or?
I believe the problem is with the schedules. It's like you've indicated, Your Honor, every court is trying to get their cases cleared. And so all of these jury settings that we have, you never know if you're going to be the one to go, because all these cases are 2020 and early 2021. So, I mean, we can set it subject there too, but the only dates I know will work for certain are March 24th and March 31st, and that's dependent upon Sergeant Quiroga's availability. I haven't verified that he was available because nobody's confirmed that they want to use those two dates.
Would that work, Mr. Van Gro, for Sergeant Quiroga?
I believe I could probably make the March 24th date work.
Okay. All right, I'm going to order the deposition of Sergeant Quiroga to occur on March 24th. I'm not sure what to do about this other guy. They say that he doesn't exist. I don't know how to order his deposition if he doesn't exist.
I'm not saying he doesn't exist, Your Honor. I'm just saying he doesn't work for my client.
And he doesn't work for mine either, and I've told plaintiff counsel that at least 3 times in writing.
And Judge, that's the issue. I do mostly agree with John House. I do believe that this person probably is not an employee of DART, given the fact that a DART detective had to reach out to somebody to get his information. So that's why I believe it's probably an Irving Holdings employee. And I'm not sure, I mean, why else would W. Shemek be able to provide information for Irving Holdings employees?
Your Honor, I believe that he may have worked for MV Transportation. This is a paratransit program operated through DART. It contracts with MV Transportation to provide these services, and MV essentially runs the whole show. So I believe that W. Shimrack may have worked for MV, and that's why the DART investigators reaching out to MV, because they would be the ones that had all the trip information and who the driver might have been.
Is this company a defendant in this case?
No, Judge.
No, Your Honor.
And the statute of limitations expired long ago.
Okay. Well, I'm not sure what to do about this one, Mr. Van Grell. I mean, I think you're gonna have to subpoena him if you want to find him.
Okay.
So, I mean, if it turns out that Mr. House or Mr. Scott is being dishonest there, then let me know and I'll sanction them. But they're saying that it's not, they don't work there, then I don't have any evidence.
Okay. So we will go with, I'll see if I can't subpoena this Mr. Shemek, and we will go with the deposition of Sergeant Quiroga on March 24th.
Okay, what did you need?
There was an attorney, he was trying to see about the connections and stuff for trial. Is now not a good time?
Yeah, have him come in.
Okay.
I think the door's open.
Yeah, it is. He said it was locked.
Is he, are you sure he's coming to this court? Oh, yeah, well, he may be in the wrong court because the door's been open for a few hours. Okay, thank you, appreciate it. All right, anything else, guys?
That'll be it. Thank you, Your Honor.
Mr. Scott, you seem to be standing up. Is everything okay?
No, I was about ready to click out.
Okay.
Nothing further from me.
So what's going to happen now, Mr. Bengro? You get me an order on this. Share it with Mr. House, because I don't think it does anything with Mr. Scott. Share it with Mr. House. Make sure at the beginning of the order, it says that this was heard on January 6th, 2023. And then get it to be no later than this Friday.
No problem.
Thank you, guys.
Thank you.
Thank you, Your Honor.
All right. Anyone here on any other cases? There's a Miss Allison here on. I'm not sure who you are. Okay, we're going to take a break.
Okay, let's see. Martin Hoffman. Start video. Jack, Bill. Hey, Jack, can you hear me?
Yes.
Oh, perfect. Okay, well, we're back to this. Just so you know, the only reason I'm doing this is because I couldn't get the hearing for another 2 weeks. So
Okay.
I hate this, as you well know, and you know I don't know how to do this. I thought I didn't have to get my learning curve into this, but anyway, crazy stuff. Hey, is your daughter an audiologist here in town, or is she out somewhere else?
She is actually working for a company that distributes the hearing aids now. She is an audiologist, yes.
Oh, I knew that, but is she audiologist in Dallas or somewhere else?
Dallas area, yeah.
Does she see people? Because I think I'm going, I'm having serious hearing. I think it's going at me since 2012. I think it's just taken
send me an email after the hearing and I'll give you a referral.
Okay, good, because I'd like to know someone.
Yep.
Yeah, okay, because I mean, I had a hearing.
Morning, good afternoon, Your Honor.
Oh, good afternoon, Your Honor. Didn't know you were.
Sorry to hear about your hearing problems.
Yeah, well, yeah. What'd you say?
You guys are here on BBVA versus Mesa, is that right?
That's
correct. Yes,
correct.
Your Honor.
All right, let's go on the record, Tony, on DC 203437 BBVA USA versus Mesa Southwest Management. Counsel, make your appearances.
Bill Wolf, Your Honor, on behalf of the defendants.
Your Honor, Jack Kirkendall on behalf of the plaintiff.
All right, let's proceed.
Thank you, Your Honor. Matt, okay, so very briefly, we have a note suit. There's 4 notes. We took a little vacation to the Court of Appeals for a while. We came down. We're now set for a summary judgment on March 17th? 17th. And I'm trying to get documents and production and answers to some things so that I can intelligently take a deposition of the gentleman who, his name is Cassell, who filed the affidavit in support of the MSJ. I submitted, if you recall, we asked for some time. My partner came down and you gave us some time. And so now we'd like to get the documents and answers, take the deposition, and then be able to respond to the summary judgment. We sent 8 interrogatories and we sent 16 requests for production. And everyone is objected to. They all ask for essentially the background and documents and calculations of the numbers that are provided in a declaration by one former employee of the plaintiff and one current employee. I believe that's true, what I just said. And what we got is every single time there was, it's overly broad and it's without fail, every single time there was an objection that the documents or that the information, for example, in the 8 interrogatories, quote, were stated in business records, which provided the requested information. And then it said the interest was manually recalculated to reflect the note rate and not the default rate. So what these numbers are in the affidavit are just conclusory statements. They're X and Y and Z and A and B and C. And all I'm trying to understand is how that number was derived and calculated. Stated in business records, there's 130 pages in one tranche, and there's 152 pages in the second tranche. And we've done a search of them, and there's inconsistencies between those documents and what's stated in the affidavit. But of course, Rule 197.2 says that if you're going to rely on records from which the answer may be derived or ascertained, must be specified in sufficient detail to permit the requesting party to locate and identify them as readily as can the responding party. That's what the rule says. Now, I guess they think there's in those documents. I can't figure them out. Of course, I don't know how their hand calculations could be in those documents. So very simply, I'm just looking to get the interrogatories to ask for the numbers that they're asking for a judgment on, not exactly irrelevant or tangential or, left out in left field, kind of questions. I mean, I literally quoted the statements in the sworn documents, both the declaration and affidavit, and said, how'd you calculate this number? How'd you calculate this number? And some of it gets really dicey, like there's like $3,000 of inspections, and we don't know that they inspected or don't know anything about the inspection. So we're looking for, is there like an invoice for the inspection? Did they provide like what they did? Because my guy's not aware of any inspections. And on top of it all, Mr. Kirkendall and I spent an enormous amount of time with the quadrangle, which tried to kick out one of the tenants. And we ended up in a, John Dice versus John Dice kind of case with, Court of Appeals and mandamus and bankruptcy. And at the end of the day, he waived his right to the collateral in that particular case, which I'm sure he'll agree that he did that. So now we're paying for inspections that never resulted in any collateral, but we don't know what they inspected or when or how or what they did or why those amounts. So we're just trying to get you can't get more core than the amounts that they ask for a judgment. So that's what we're asking, is to say, waive those objections, find that they're good, solid questions. I don't know how much we discover. I mean, it's to defend against the amounts they're seeking. It couldn't be clearer and more on point than that. And then the documents that relate to it. And like I said, if you give me 300 pages and you say that pony's in that haystack, I don't think that's the rules. Stated in the business records, that's what it says. If that's specificity, no reason to send interrogatories. Just send a bunch of documents. That's all I got.
Thoughts?
Your Honor, the business records exception was used in the summary judgment motion was used to produce all of the underlying documents. And then the payoff amount, the documentation for the payoff amount, computer generated, was also produced to Mr. Wolf. And the documents in the business records reflecting a few expenses, some site visits and some appraisals, was also produced to Mr. Wolf. And if the interrogatories, basically the bank employee / officer would ask for a payoff, and under the clear Texas case law, a bank officer, bank president can testify is considered to be competent to testify as to the amounts owed. I produced the records from which they came up with the amounts. Now, if Mr. Wolf can be more specific about exactly what he's looking for, I'd be happy to give him that information. The interrogatories, a detailed explanation, I can repeat those and just tell him what we did with respect to the business records exception to come up with the amounts owed. If he wants me to go through the business records exception and explain how the computer works, how they came up with the documentation, et cetera, that went into the computer. I did produce form payment histories as well. Now, that was done recently, but payment histories would show the amounts that were paid, would show the et cetera. We did give him documentation reflecting in the computer the site visits and the appraisals. If he wants copies of appraisals or some kind of record of a site visit and the expenses, I'd be happy to do that for him. But the way that these requests were worded were very broad. For instance, asking for in the documents, basically, there's a series of requests in here that say, now these notes, let me say this, when you go back with these promissory notes, they're dated 2012, 13, and 14. So a series of these notes, rather of the requests, say, please produce any and all documents evidencing any communications between plaintiff and anyone, including internally within plaintiff or any third party, referencing any of the amounts set forth in one of the interrogatory answers, or any of the items which make up, when added together, any of the amounts set forth. And so basically to comply with this, and I've objected overbroad, to comply with that, I would have to go back to 2012 on one of these notes and have the clients try to dig around 2 banks ago and try to find what documents reflect a payment in 2012 or 13 or whatever. So they're overbroad. If he can narrow it and tell me what he wants specifically, And if I owe him more documents, or if I need to amend the interrogatory answers, I'll be happy to do that. But I need to know more specifically what he's asking me to do. I mean, literally, if I tried to comply with a couple of these things the way they're worded, we'd be going back into, I don't know if they still have documents in warehouses or something to try to find emails from 2013 concerning a payment that was made on one of these notes or things like that, which is outside the scope of discovery anyway, because there's absolutely nothing to do with the amount that's owed today. And so, again, I think that the request as they're worded are far too broad. And very vague. I don't really know what he's looking for, to be honest with you, Judge. If he's looking for receipts for an appraisal or something like that, I can we can dig those up.
So let me just, I think we're kind of talking in real generalities. Right. Can you go ahead and show me what request exactly you want me to respond to, Mr. Wolf?
Yeah, they're very similar. They're actually laid out in his response, and there's interrogatory 1 through 4, and they ask for literally the amounts in the sworn documents. I mean, one after the other. The amount, the principal, the expenses are $7,652. How is that calculated? And they're not in business records. Just as an aside, Your Honor, I'm looking at the amounts for Mesa Southwest Dallas, and the declaration says one amount and the payoff says another. So I don't know how to, it's not helpful to tell me that I've got documents that say something different. It's impossible. And what you're hearing is something that's very dangerous about the case law, is that these people say that they're officers and they have personal knowledge, and they put out numbers and they're just conclusory numbers, and I don't have any way to attack it. And what he's saying is, look at 300 pages that's in there. So the 8 interrogatories are literally stated in his response, verbatim, and every time he says, as stated in the business records, which doesn't apply with 197.2. And then the requests for production are either documents evidencing any communications between plaintiff and anyone, including internally, with respect to those same numbers. In other words, if they're talking to the appraiser or someone saying send someone out, I'm just looking for the documents that relate to the amounts that they're asking to get a judgment against my client. This is not far afield from anything. This is about—
You want an invoice?
Pardon me?
Do you want invoices? Is that what you want?
I want any documents that relate to those numbers. Did you go and get an appraisal? Are there emails that say that we're going to do an appraisal and it's necessary? We're going to waive the rights? Are there— I don't know what's there, but I mean, everyone has. If you don't have documents because they're gone, it's 2 banks later, then you don't have possession, custody, or control. I don't know how that can be a problem. If you don't have them, you don't have them. So it's basically documents related to those amounts or communications related to those amounts.
Well, again, the communications related to those amounts go back 10 years on some of these.
I doubt it, because these amounts are literally calculated in the last year or two. I doubt that when it was 6 or 8 years old, those amounts are referenced. In other words, the amounts are the amounts you're asking for either in the last 2 years or so. This is a very narrow set of requests.
The first request is interrogatory number 1, correct?
Correct.
Okay.
That's directly out of a declaration sworn to by a bank officer.
All right. Objection to interrogatory number 1 is overruled. You need to be ordered to produce that. Interrogatory number 2.
Straight from his declaration.
Okay, let me just read it first.
There was 4, Your Honor, because there's 4 notes.
Oh, they're all the same. Okay, so 1 through 4 are all granted, or the objections are overruled. The need to answer the interrogatories. Number 5.
Now I'm talking to a nut. This is Cassell, who's a different bank officer, and he's got 4 notes and 4 sets of numbers, different than the other. Straight out of he's an affidavit.
I'll re-answer 5 through 8 because they're going to be the same, except for.
All right, so objections to 5 through 8 are overruled. You need to answer those.
Can I ask a question, Your Honor, on the interrogatories?
Go ahead.
Yeah, are you looking, Bill, for how the categories were and expenses were calculated I mean, do you want me to say that the payments were entered in the computer? Are you looking for the computer, the business records exception? What are you looking for?
I'm just looking for how you came. The problem is a conclusory endgame allows you to get up and cite those cases that says Joe Blow says that the debt is X and I'm dead. I'm saying, no, I need to understand X so that I can look at it. And the interest fluctuates. It moved over time. So I need to understand how you got there. Just A, B, C. How did you get to those amounts? That's what you're.
All right. Well, best, Your Honor, I'll redo 1 through 8 interrogatories.
Okay. Correction number 1.
Yeah, and these are just the same amounts.
Okay. Objections overruled. Interrogatory number 2. Objections overruled.
Then the rest of them are basically the same thing, different amounts.
Okay, it's all overruled. You need to go ahead and answer.
Yes, sir.
I'll get you an order.
Go ahead, get me an order. At the beginning of the order, Mr. Wolf, go ahead and say that this hearing was heard on February 6, 2023.
Okay.
That make sure you share a copy of the order with Mr. Cloakendale and get that to me if you can, okay?
I will do it. How long does he have to do it?
He'll have 14 days and you will have, you need to get me the order by this Friday.
I will do that.
All right.
But 14 days from today.
14 days from the date of the order.
Oh boy, because then I'm going to get caught up in the depot and response to summary judgment. I'm happy to give him 2 months. I just need to make sure I got enough time after I get it to take the depot.
Your Honor, may I raise another subject that might address that at least a little bit? I was going to see if we could move the summary judgment hearing back a week. It's sedated. It's scheduled for March 17. I'd like to do it March 24 if that's possible.
Well, that would be better for the issue I'm raising for sure.
Okay.
I don't know about like 24th as the date, but I'm happy to move it in the future.
Let me just say this, it's totally up to y'all. So the 24th is fine, but it will be in person.
Right.
Do it remotely, we can do it on the 27th or the 20th.
I prefer in person. I only did this because I couldn't get person till later, and I need to get this to hit the squeeze fire drill here of having.
Okay, just want to make sure you knew. So Rhonda, go ahead and reset the summary judgment on this case. Currently set on the 17th to the 24th, and we'll do it at 10 o'clock again.
Thank you, Your Honor.
But if he gets 14 days from Nick, from
Bill, I'll answer it before that.
Okay, well, why don't we just say like 10 then?
10 days.
I'll agree to do it 14 days from today. How about that?
That sounds good. Okay, sounds
All right.
good. Thank you, Your Honor. Are we excused?
Make sure you get me the order, though.
I will. I for sure will.
Thank you, Judge.
Thank you, Judge.
Judge said it Monday at what time?
10 a.m. I think.
10 a.m. on the 24th.
On the 24th, March 24th.
Yeah.
Oh, March. Okay. March 24th.
Thank you, Your Honor. Are we excused?
You are excused. Thank you so much.
Thank you, Judge.
Thank you. Bye.
Okay, I think we have one more hearing at 4:15. Both sides here on A Better Place versus LLC versus Melissa Allison.
Yes, Your Honor.
Yes, I'm here.
All right, Tony, you ready?
Yes,
Tony?
Judge.
Let's go on the record on DC 2114-106. Council, make your appearances.
Yeah, William Seig representing A Better Place.
Miss Allison, go ahead.
I'm sorry. I'm here. I'm trying to figure out how. Oh, here I am. Okay, yes, I'm here.
Okay, let's proceed.
Your Honor, for some reason, I can't seem to get my picture up on the.
Okay. Go ahead and go.
I'm sorry.
Go ahead and go forward, please.
Okay, yeah, this is what had happened in this case was that this was a suit to partition real property. It was coming up for a trial, non-jury trial, and the plaintiff's counsel filed bankruptcy the night before the trial. It was stayed during the bankruptcy proceeding. The judge, the court issued an order giving us, stating that we have within 30 days of the close of the bankruptcy proceeding to have a motion to reopen. I filed the motion. It was, and I'm sorry, I'm going through it. The bankruptcy case. The bankruptcy court closed the case on December 5th, and then we filed the motion to reopen within 30 days.
It looks like Ms. Arnold, your attorney is trying to withdraw. Is that correct?
Me? Yes, it's Miss Allison.
Is your attorney trying to withdraw?
Yes, I've been checking. It's not like his area of expertise. I've been checking and looking around because this is all kind of new to me as well, and kind of caught off guard by a lot of stuff. So I am trying to check for another attorney at the moment. I don't know if I will find one that can work with me, but I don't know how steps will go from here.
Okay, I'm going to go ahead and reopen the case. Your attorney is not officially withdrawn yet. We're going to go ahead and set this for trial. When would you like me to set this for trial?
I guess whenever it happens, it happens. I mean, I'm just kind of going with the flow and trying to take care of things as I can. So
Can we set it for 90 days, Your Honor?
Sure. Let's go ahead and set it. Rhonda, if you're there, go ahead and set this for trial on how does May 9th sound?
That's fine, Your Honor.
yeah, yes, that's fine.
Okay, I have it.
All right, go ahead and set it on May.
Can I ask you, Your Honor, is there going to be a hearing or a ruling on the Miss Allison's attorney to motion to withdraw? Because I don't know who to deal with at this point if I want to negotiate a resolution.
At this point, he is still counsel. Let me see. He submitted a motion to withdraw. Miss Allison, you agree to the withdrawal?
Yeah, well, I was trying to look because I'm just trying to, like I said, take care of matters, come up with money, and it's, here I've been dealing with a lot of plumbing issues and broken pipes with the freeze and things. So just checking and seeing who I can work with or trying to get loans to take care of this business here.
I'm sorry to hear that. I will go ahead and allow the withdrawal since it's agreed to. So you'll need to deal for now directly with Miss Allison.
Okay.
Okay.
All right. Thank you, Your Honor.
I'm signing the order right now.
And it's for May 9th, 2023.
Correct.
Okay.
You'll need to have mediated the case prior to that.
Okay. Yes, Your Honor.
Thank you, guys. You have a great day. You be safe, okay?
Thanks.
All right. Thank you. Stay
Thank you.
blessed. Thank you. Oh, wait.
Ron, can you come on in here real quick?